Losing a loved one is undeniably one of life's most challenging and heart-wrenching experiences. In the days and weeks that follow a loss, families need time to grieve, reflect, and support one another. While you are navigating this heavy emotional toll, the absolute last thing you want to worry about is a mountain of complex legal paperwork and court procedures.
Yet, in Massachusetts, grieving families are often thrust into the daunting probate process right when they are most vulnerable. But what if there was a way to simplify this? Today, we are exploring the voluntary surrender of probate. It is a legal avenue designed to bypass traditional hurdles, offering your family some much-needed relief. To understand the voluntary surrender of probate in Massachusetts, we first need to understand what probate actually is. Simply put, probate is the legal process through which a deceased person's estate is properly administered and resolved under the supervision of the court. The process generally involves 4 main steps. First, the court must validate the deceased person's will, ensuring it is legally binding. Next comes the asset inventory, where all properties, bank accounts, and valuables are identified and appraised. Then, any outstanding debts and taxes owed by the estate must be paid. Finally, the remaining assets are officially distributed to the rightful heirs or beneficiaries. While probate serves an important protective function, it is famously public, time-consuming, and often expensive. Families are frequently caught off guard by the months or even years it can take to finalize an estate, not to mention the legal fees that slowly chip away at the inheritance. For many navigating the system, finding a simpler path becomes a top priority. Have you heard the phrase voluntary surrender in Massachusetts probate and wondered what it actually means? Let's clear up the confusion right away. In Massachusetts law, voluntary surrender isn't an official legal term at all. Instead, the court officially refers to this action as declining to serve. This happens when someone named in a will as an executor realizes they cannot take on the immense responsibility. Making this difficult decision is a completely valid and responsible choice. To make it official, you simply file a formal declination with the probate court, allowing another qualified person to step up and handle the estate. Being named an executor may seem like an honor, but it's a massive responsibility. In Massachusetts, you have the absolute right to decline. Why do people step away? First is the immense time commitment. Probate can drag on for months. If you're balancing a career and family, you simply might not have the hours to track down assets and file court documents. Second is a lack of expertise. Managing an estate involves complex financial statements and intricate tax returns. If you lack a background in finance, it's easy to get overwhelmed. This ties into the fear of personal liability. As executor, making a significant mistake means you could be held personally and financially responsible by the beneficiaries. Then there's the emotional toll. Grieving is hard enough without the added stress of legal paperwork. Furthermore, acting as executor can put you in the middle of toxic family disputes. Distributing inheritances often ignites underlying tensions, creating painful conflicts of interest between relatives. Finally, personal health matters. A serious illness might prevent you from taking on such a demanding job, or you might simply have no desire to do it. You don't have to justify your decision to the Massachusetts probate court. Declining is a completely valid choice. Stepping down as an executor in Massachusetts requires a specific legal process. The very first step is to carefully review the last will and testament. Determine if a successor or alternate executor is named, as this dictates your next steps. Next, draft a formal letter of renunciation, clearly stating your intention to decline the executor role. Once signed, file this form with the Massachusetts Probate and Family Court in the county handling the estate. This officially removes your legal obligations. After filing your renunciation, you must notify all interested parties. A quick email or text message notification is a good start, but formal written notice to beneficiaries and alternate executors prevents confusion and delays. Finally, navigating state probate law is complex, and mistakes can cause estate delays. Consulting an experienced Massachusetts estate planning attorney is highly recommended to ensure your voluntary surrender is executed properly and legally. So, what happens after a personal representative voluntarily steps down in Massachusetts? The probate process doesn't just stop, it transitions. The immediate legal aftermath involves filling the vacancy left by the departing executor, so the estate administration can continue smoothly.
How this vacancy is filled depends entirely on the estate documents. If there is a will that names a successor, the court will typically honor that choice. But if there is no will, or no successor named, Massachusetts intestacy laws take over. The court will appoint a new administrator, often starting with the closest family members or primary beneficiaries. Ultimately, the transition becomes official only when the Massachusetts Probate and Family Court formally accepts the resignation and appoints the new representative. Once the judge signs off, the new executor steps into the role, assuming all fiduciary duties to finally settle the estate and distribute the remaining assets to the heirs. If the responsibilities of being an executor in Massachusetts feel overwhelming, you do not necessarily have to resign completely. One practical alternative is petitioning the court to appoint a co-executor to share the burden. You can also retain the title but delegate the heavy lifting by hiring professionals, such as probate attorneys or estate accountants, paying their fees directly from the estate. Additionally, if the estate is relatively small, you might qualify for voluntary administration, a much simpler and faster process. In Massachusetts, this streamlined option is available for estates consisting entirely of personal property, valued at $25,000 or less, excluding a car. This path drastically reduces paperwork and court involvement. Always be sure to verify current legal limits, as threshold amounts can change over time. When an estate goes through probate in Massachusetts, there are a variety of costs to consider. You can expect to encounter court filing fees, executor compensation, and potentially significant attorney fees. If the court requires a surety bond to protect the estate, that will be an additional out-of-pocket expense. These costs can quickly add up, reducing the final inheritance passed down to beneficiaries. Beyond the financial cost, the timeline for probate can be unpredictable. While a simple, uncontested estate might be settled in 3 to 6 months, more complex situations can drag on for well over a year. The process involves mandatory waiting periods for creditor claims, filing inventory reports, and gathering all necessary documentation. Several key factors dictate just how long and expensive this process will be. Whether there is a valid will or no will at all plays a major role. Additionally, the overall size of the estate and whether any disputes arise among family members or creditors can significantly delay proceedings and drive up legal expenses. Navigating the voluntary surrender of probate in Massachusetts can feel overwhelming, but you do not have to do it alone. Always consult with a qualified Massachusetts probate attorney to ensure your specific legal needs are handled correctly. For more resources and guidance on managing end-of-life matters, please visit funeralus.com. If you found this guide helpful, please like, subscribe, and leave a comment below. We are here to support you every step of the way.